All right, we're going on the record on cause number DC 204618, Jimmy Benedito versus Mr. Towing LLC. Counsel, make your appearances.
Morgan Carell with the Melendez Law Firm for the plaintiff.
Megan Ferris with Steed, Donald Reynolds, Bailey Stevenson for the defendants, Mr. Towing Inc. and Hector Lerma.
Okay, so this case has a bit of an unusual twist to it. Somehow a hearing got heard by another judge. In this case, I don't know exactly what happened. How did that happen?
Well, I think the petition was filed or we filed our answer in the 95th. I'm not sure which happened first, but whichever way it happened, our docket sheet showed the 95th. And so, and I think so did plaintiff's counsel. And so when they submitted their motion to compel or their motion to quash, excuse me, and we responded in the 95th. So it got set. And then kind of in the middle of the hearing, I believe Judge Lee sort of stopped us and said, why is this in my court? And so we went back and looked and realized that it was just it was an error on our part, and our docket sheet was just wrong.
There's no allegation here that someone was trying to forum shop, is there?
No.
No.
Okay. All right, go ahead and make your argument.
So this is plaintiff's motion to quash. Morgan, I don't know if you want to go first or.
So the background of this one is basically quashing their requests for quite a few of these providers. And Ms. Ferris and I had kind of come to an agreement for the providers that 5 years was a good time frame and 1 year for the hospital. I believe where our contention is now is that we would like to receive the records first and have the chance to redact them for privileged information. And Ms. Ferris would like the records presented to her unredacted.
Yeah, that's how I always do it. My standard is that any treatment after the accident related to the same areas of the body would be produced, and any treatment up to 5 years prior to the accident to the same areas of the body would be produced. And in these types of situations, I usually have the plaintiff's attorney take a look at the records before they're produced to the defense attorney, and then there's some kind of dispute in that process, then you bring that to the court. That's kind of, I don't know about the other thing you said about 1 year for the hospital. I'm not sure what that's about, but if you guys want to agree to that, that's fine with me as well.
We did, and we were fine to agree to it. Sir, I think our concern just came from these records have been asked for many months. They are the treating providers for the plaintiff and are not privileged from our perspective and should not need redaction, especially if we're limiting it to 1 year for the ER and 5 years for the treating providers. The defendants have to know the status of Mr. Benedetto's legs and knees, which is what he's alleging, are the damages in this case. And so we believe we're entitled to the records unredacted.
Yeah, if it's related to the same areas of the body so the plaintiff is claiming, then yes, you are. But I don't know if one of the providers is, say, for example, a physician, a PCP, then the PCP may be treating the person for a lot of different issues during the 5 years prior. And if they had a, COVID test 6 months ago, you're not going to get into that, or if they had a, rash on their armpit and that's not one of the claims, then you're not going to get that. So that's kind of why I do it this way. But if it's related to the same area of the body that is claimed in this case, then anything with any treatment within 5 years prior, you need to produce.
Yes, sir. So the list of providers that we are asking for is the list that the plaintiff gave us of the providers that treated him for his injury. His PCP is not included. It's orthopedic surgeon, chiropractor, foot and ankle surgeon, physical therapy, and the ER.
Ms. Curell, had your client seen any of these providers before the accident?
I don't believe so. However, there was one hospital, which is why that one we had discussed limiting it to a year instead of 5 years. Usually we just get these records first, and we're not trying to redact for anything that's, related. It's just their social security number, you know,
Oh, yeah,
like
that
the
makes sense.
early,
Okay,
something
do you have
unrelated.
a proposed order for me?
I can send one in if you have an email.
Yeah, send it to my court coordinator, Rhonda,
Okay.
and make sure you follow it as well.
Okay. And what was the ruling on that?
Oh, what I just said.
Was that with redactions or?
Oh, you're going to review the documents and then you can redact them to take out any social security numbers, you know, and then any unrelated treatment.
Okay.
And then you turn it over to the other side.
Okay. I'll send that to you then, Ms. Ferris, first for your review.
That's fine.
Okay.
And I will say this, in you know, Ms. Ferris's defense, if it's all treatment that's only related to this accident, I don't know that you need to go through that process. I mean, it's, I mean, this is intended to try to deal with issues, pre-existing issues that aren't related. So if everything is, you know, if these are LOP doctors that the client went to, then you should just give them directly to her. But I'm not making that. I'm just suggest just a suggestion, and just to make this easier and quicker. When are y'all set for trial?
Oh gosh, I am not sure.
Let me take a look.
We have not exchanged discovery or anything because we don't have the records.
Okay. It's a little confusing. I have July 6th and July 20th. Did I reset it to July 20th for some reason, or do y'all know?
Oh, you may have. Let me look and see let me see if on my docket sheet what I've got.
I think it should be July 20th, I believe, but it's kind of weird. It says July 6th and then it says July 20th.
So what I have, yes. So the latest document from the court on September 17th shows a trial date of July 20th. Yes, sir.
Okay.
Yeah, that's the date I've got.
Anything else we need to chat about, guys?
That was it.
No, Your Honor, I think that's it.
All right. You guys be safe, and we'll see you at the next one, okay?
Thank you so much. Appreciate it.
Guys.
Bye.
Bye-bye. Okay, so we have one more hearing today at 2:30. Any questions about any of the, and Tony, I got your, and Rhonda, I got your emails. Thank you for that. And that will help a lot for what we're doing. Did you send that email to, Tony, did you send that email to Rhonda as well?
I did.
Rhonda, can you print out all, were there attachments to that?
Yes.
Rhonda, can you print out the attachments and put them into a binder? Okay. All right. Tony, Rhonda, we'll see you back at 2:30, and then why don't the intern stay on for a second?
Okay.
Okay, guys, any other questions about the hearings we just had? It's okay to ask questions. Do you have any questions? No? Okay. All righty. Well, then I will see you guys back at 2:30.